Hello everyone, welcome again to this YouTube channel. So for today's video, we will talk about basic principles in criminal law. So let's start first defining what is criminal law and what is a crime. So as you know, criminal law, this is a study of crimes. It is also a study of the truth of their nature and also provides punishment. So criminal law could be under the revised penal code, or it could also be special laws. We have discussed, or I have discussed, the difference between the revised penal code and the special laws in my previous video. So yeah, that's criminal law. So it punishes an act that is in violation of the criminal law, whether RPC or special law. Crime, on the other hand, crime is considered, can be an act, or it could also be an omission, which is a violation of a penal law, or it's a violation of a law, RPC or special law. So crime, it's not always overt act. It's not always doing what is prohibited under the law, but there's also certain crimes where, or law, which punishes omission. So not doing what the law says that you should do is also considered a crime. So in my book, in the Introduction to Criminal Justice, published by Rex Bookstore, I specifically mentioned there, as you know, as a trivia, what comes first? Is it a crime or the law? So by definition, crime is an act or omission punishable by law. So in short, if an act, an overt act, or an omission, or not doing something what the law says that you should do, but that is incorporated in a law, it could be a revised penal code or special law. So basically, if there's no act or there's no omission as prescribed under the law, then there's no crime. So an act or omission can only be a crime if there's a law that says that doing this is a crime and not doing this is also a crime. So what comes first is basically the law, and then it follows the crime. That's why there are, if you've heard in the news or if you've read it somewhere, that's why lobbying decriminalization of an act. So for example, mendicancy, asking pennies in the street or begging money, so very common. Before, mendicancy is punishable under the revised penal code, but as of the moment, mendicancy considered a crime, so it was already decriminalized. That's why if you have seen people asking money in the streets or wherever, then that act is no longer punishable under our law. It was already decriminalized. So with that effect, going back, so law comes first before the crime, because the crime is basically basing on the law. Okay, so I hope it's clear. Now let's proceed to certain principles in criminal law. I'll start with mistake of fact. So very important to know that by principle, mistake of fact is a form of defense. Okay, it's a form of defense. So whenever a person commits an act, raising mistake of fact can extinguish the person's liability. Why? Because in the case of US versus Achong, this is the case that gives the principle, or lay down the principle of mistake of fact. So mistake of fact, according to the Supreme Court, is considered to be a self-defense. So it is a concept where if the person, the actor, believed that the act, the act in front of him, or the act that is, for example, I'll just give you an example in the case of People versus Achong. So Achong was a chef, and then Achong has this board mate, the assistant chef, and they had an agreement that whomever comes late, you need to inform the person who comes first, that hey, I'm this, I'm Achong, and I'm the assistant chef, or whatnot, because at that time burglary is very popular. So Achong was already in the room, and Achong, to defend himself for possible attack or burglary, actually prepared a knife, under his bed, under his pillow. But that point was actually known to the assistant chef at the beginning. So there's a person knocking on the door. So Achong kept on asking, hey, who are you? And warned the person at the other side of the door that he has this knife prepared. So if you will forcibly open the door, I have no other choice but to stab you. I have this knife in me. Okay. In fact, Achong put a wooden chair at the door in order for the person not to easily enter. But since the other person at the door kept pushing, forcibly wants to enter the room, so Achong, believing that the person was actually a burglar, or whomever, or the person has this intention to attack him because of several reminders that he has this knife and all of that, but the other person did not heed the warning, but instead kept on pushing and forcibly wants to enter. So the person able to enter the door or the room, so Achong stabbed the person. So Achong was prosecuted for the crime, and then the Supreme Court said the killing was actually covered under self-defense, justifying circumstance. So the Supreme Court said, had it been that Achong knew that the person who attacked him was the assistant chef, then Chong would not have done such act. So mistake of fact is actually misconception, but the misconception of the actual act is not attendant of any fault or negligence on the part of the actor. And had it been what the actor believed it to be could have been true, then in any way the person could have also been covered under justifying circumstance, particularly self-defense. That is why, by principle, mistake of fact is a form of defense. The second principle I want to discuss is the principle of Praeter Intentionem. So if mistake of fact is a form of defense because it will justify the act of the person, Praeter Intentionem, on the other hand, would not totally justify but will mitigate the penalty of the violation of the person. Well, if you look at it that way, it could be a form of a defense in a way that you will use that in order to mitigate the penalty. So by definition, Praeter Intentionem is the result of the act of the person is so grave a wrong as that intended. So the intention of the person is only up to here, but the result exceeded. So the result is so grave a wrong compared to the intention of the actor. So claiming that or using that in the defense of the accused, that could be considered as mitigating circumstance. For example, all you want is to punch. All you want is just to injure the person. However, out of your control, the person may be imbalanced and then shock his head in the floor, which causes death. Could you be held liable for the death of the person? The answer is yes. But it's not my intention to kill the person, yes. But had it been, or by principle, if you did not punch the person, then the result could not have happened. But since your intention is not so grave a wrong, then although you'll be held liable of the death of the person, but the penalty will only be mitigated. So the rule of thumb is, in Praeter Intentionem, is that you should be performing an intentional felony. Okay, you should be performing an intentional felony. So I always reiterate this to my students that the principle in criminal law is, if your act is a crime or a violation of a crime or a violation of the law, whatever is the result, you will be held criminally liable. But if your act is not a crime, it's not a violation of any law or whatnot, then whatever is the result, you will not be held criminally liable. Maybe civilly, but not criminally liable. In fact, that's the concept of pure accident without your negligence, without fault on your part, is actually an exempting circumstance. Okay, so that's for Praeter Intentionem. So we discussed in this video what is criminal law, what is crime, what is mistake of fact, and what is Praeter Intentionem. So I hope you've learned from this video. And just a disclaimer, this is not considered as a legal advice or a video that would create a possible client or lawyer relationship or whatnot. And please don't rely on this video alone. Please do your reading as well. Okay, thank you, and I hope this helps. Bye!